Indian news ma kwaba assign the ba wan kasa fidie so bio. Na maka trust before anything else na just a share na ebiem so kwa na wo subscribe to your channel no. What's the political news there? Never governance. We catch you sapani put of ma yet. Na panye to forma yet there. Ane na nsem foforo bi enso asan esi. Benim say what the nsem ade ban na ya na ya wote na ya wohwe na ya wofen so. Nti no nsem foforo bi esi a India news yan so pani ye to for me baby ati nyina chi no ye nsa atumi aka bi na yaso enso atimi atisa ensemi bi yentie nsem member sisi a na mpanifo mpo se kakum no ye che no koku enum de ba before that no subscribe to your channel no sabeka all other news fa politics one the opesa wotie no eho etie ba ebe baby asusu anso person de body no fa na de asie bia no so fa comment enso to ase ne yenkenkan informaw de ready na emeko yentie nsem member sisi a utie no fa comment to ase ba de emfa nchemu no so ento aso yentie mra.
Statement by the majority leader yesterday in Parliament that regulations, a set of regulations were going to be introduced, not an act. Regulations were going to be introduced to govern the removal processes of the Chief Justice has strengthened my position that, first and foremost, Article 146 of the Constitution cannot be operationalized without regulations. And I will tell you why. My brother, take your phone. One of the grounds, take your phone. One of the grounds for the removal of the Chief Justice is stated misbehavior. Google what the definition of a stated misbehavior is.
Right.
It's not defined by any law. It is not defined by any law. How do you go through any proceedings not knowing the definition of what offense that you have committed? Because you see, ahead of time, everybody ought to know that this is what constitutes stated misbehavior. And so in going through the proceedings, you know that this is where I am said to have erred. And therefore, the burden on whoever has accused me of one offense or the other is to prove A, B, C, D. And in my defense, this is what I also did to demonstrate. But as we sit here, what constitutes stated misbehavior is not known by any law. It's not known by any law. Secondly, how do you go through? How? In the absence of a specific definition for stated misbehavior, how was the prima facie even established? What were the elements for the consideration of the President and the Council of State? What went into that? Because it is not defined by any law. It is not defined by any law.
So what was the Chief Justice responding to? You know, she responded
that
to
is,
some... So if she didn't understand that there was some stated misbehavior, for which reasons that those petitions were raised against her, why didn't she question that from the onset, but went ahead to respond to these petitions?
I'm not her lawyer, but I can imagine that she was responding to the allegations that have been made against her. You see, for every charge or offense, even in employer-employee relationship, there is always a definition. Take your employee manual. Take the employee manual of Joy FM, multimedia, and you will discover, right, the very things which are deemed to be an infraction, for which reason you may, right, be held or you may be hauled to a disciplinary hearing. When you take even your employee manual, you discover that there's a definition for all the things that may result in you having to be subjected to disciplinary proceedings. Okay? And so that is how it works. You say that somebody may be removed, a judge of the Superior Court or the Chief Justice may be removed for stated misbehavior. I ought to know which of my actions or inactions will be deemed to be stated misbehavior. As we speak, there's no definition.
You're trying to draw a line between allegations as raised in the petition, which, determine the prima facie case that, consequently brought us here, where we are probing the case to see exactly what happened. So if it turns out that through the investigation,
after this fufu and pepper soup, I'll go score goals like...
come up with this stated misbehavior, then do you have a case?
No, wait. That is where the
Right now, there are allegations that she's done something wrong, for which reason we are probing the matter. And you are saying now that we haven't clearly defined what stated misbehavior is. But the Council of State established a prima facie case against the Chief Justice, for which reason we are probing the matter. So will we not eventually arrive at the stated misbehavior?
So you have to appreciate this, sweetie. When you look at the jurisprudence of the Republic of Ghana, a person can never be held accountable or charged for an offense which ahead of time that person doesn't know exists. Wait. And the ingredients of it, that is the law. That is the law. There's no law in this country that can make you accountable for something which you don't know of.
At this point in the process, can you still make this argument? Fine.
Are you going to allow me?
Yeah, go ahead.
The interruptions, very respectfully, are not helping. That is why I started from the outset that in the absence of a regulation, you cannot operationalize Article 146. The regulation would define for you what amounts to stated misbehavior, so that ahead of time, I know which aspects of my conduct would be deemed to be stated misbehavior. It is not post my conduct, then somebody comes to say that this conduct is stated misbehavior. Do you know what that is? That can lead to arbitrariness, which is the exact thing the Constitution frowns upon. The Constitution requires transparency, accountability, and to prevent arbitrariness, where somebody can look at your face and say that I don't like you. And so this conduct of yours amounts to stated misbehavior. This is what the Constitution frowns on. My point is that in the absence of a clear, advanced definition of what amounts to stated misbehavior, it is difficult to establish a prima facie case. That would also be an arbitrary exercise, because then it is post the person's action that you are now coming to decide that this conduct is stated misbehavior and that conduct is not. That is not what our law, right? That is not what our law envisaged. And so when you look, for instance, under Article 19, Clause 11 of our Constitution, it tells you that no person can be prosecuted, can be convicted for an offense unless the offense is provided for by law and the punishment for same is also stated by law. Okay? Now, when this whole exercise started, we're told that the president was going according to the Constitution of the Republic of Ghana. There was no constitutional infraction. Supposedly, the implication of it is that Article 146 is sufficient. If it is sufficient, why the need for a regulation now? Okay, the admission that there's the need for a regulation in and of itself is an implicit admission that Article 146 is insufficient. Article 146 without a regulation.
Are you opposed to these new reforms, legislative reforms that
I have always championed the need for a regulation. That has been my position from day one. And that for me is progress. The sad thing, however, is that when you are now making this admission, there is somebody who is going through that injustice, right? And so you are going to take that step to protect those who are not going through that process. But what about the Chief Justice?
You know,
one man's injustice is another man's injustice.
In a totally unrelated matter, but just to make a point, when the case of the chairman of the board of, on the board of Bank of Ghana, and the issues that came out that he has two positions that contradict the position. He can no longer do his oversight power because he was a member of the Financial Committee in Parliament and sitting on the board. We spoke to Stika, and he said that it didn't really it didn't mean that they should remove him right now, but they should begin the processes to, fill those loopholes in the Constitution. You are saying now that the introduction of these new reforms, legislative reforms that was introduced yesterday by Mahama Yariga, in itself is an admission that there's something wrong with the processes that they already started, but somebody is going through that. So at what point do we start to overhaul all this, and where do we start from? Briefly, and then I have to go back to Hamza.
I think you are very respectfully comparing apples with oranges.
No, there was the same narrative from your party, opposition. He said that it doesn't matter. We can't remove him right now, but let's begin to start the process to, fill the loopholes. Let me land. I listened to you. Let me land. He's saying the same thing that you are saying right now, but you are saying the opposite of it. You're saying that the process has been started already, and so if we are starting these reforms, it means that someone is already being treated unjustly before we are coming to seal these loopholes.
I made a point. Yeah. If you were very respectfully listening to me, you'd have appreciated that my position is that you cannot operationalize Article 146 of the Constitution without a regulation.
All right.
In that regard, my position is that operationalizing it without a regulation is unconstitutional.
Okay.
It leads to arbitrariness.
Okay.
Because
so everything we are doing right now, in fact, the entire process of removing not removing, because let me just say, listening to the petitions.
I dare say that in the absence of a regulation to govern Article 146, the enforcement of it, and I want, because sometimes the captions say, I dare say that in the absence of a regulations to govern Article 146, the enforcement of it is unconstitutional because it leads to arbitrariness. It leads to people now deciding what amounts to, for instance, stated misbehavior, which is undefined by any law. Then people will post people's action, now decide whether the action is stated misbehavior or not. That is unconstitutional.
All right, Naneje, thank you. I'll circle back to you. It
flouts every principle that underpins our Constitution.
The opponent here is saying that everything we're doing right now is unconstitutional. We are treating the Chief Justice unfairly. And this is on the back of the introduction of these legislative reforms that we are going to introduce. And just to quote, he says that President Mahama is determined to fast-track legislative reforms to strengthen our institutions of governance and further entrench our democracy. He's saying that he's not opposed to legislative reforms, but at this time where there's already someone suffering for the same constitutional provisions that he's calling, arbitrary, that's where the problem is. What do you say to that?
I think, first of all, it is important to understand that government is a continuum. And so when the majority leader made the statement in Parliament, it was simply to manifest or make public the plan of action by the Attorney General's Department for the year. It does not necessarily mean that many of these bills will go through before the end of the year. That's what we need to appreciate. Secondly, per my checks, these are works that the NPP government started. And so it was forwarded by the Attorney General's Department to that of Parliament as a way of informing them the intended plan of action for the year. That is not to say that this government would not pay attention to many of these proposed legislations. It will be taken through the necessary process, and if need be, including that of the regulations that my brother is calling for, if there's the need for us to let it go through, why not? We'll let it go through. But you see,
that means that the Chief Justice would have already been treated unfairly. And if it comes to it, removed from the same provisions
that is the beauty of the law. That is the beauty of the law. To quote Chief Justice Torkonu, the law is the law.
Well,
you see, the beauty about it is, especially in respect of our Constitution, it's the living organism. It grows. And so the fact that the Constitution grows does not mean that many of those who were found culpable under the laws before it grew should be reversed. The likes of Charlotte Osei have gone under Article 146. Loretta Lamte and co. The same law. But I am struggling to appreciate the assertion by my brother that stated misbehavior is not defined under our laws.
Google it.
Please.
Hold on.
You see, I was quiet. Oh no, you see, I was quiet.
Yeah,
you see, it has been beautifully defined by our law courts. In the case of Loretta Lamptey and the AG, the courts defined stated misbehavior. Unless, of course, you want to tell me that what comes out of the courts do not constitute part of the laws of this country. Same with Charlotte say, it was defined. Remember that even in their definition, it was concluded that infractions, procurement breaches, constituted stated misbehavior. Today, we have a Chief Justice that admitted publicly to breaching a travel policy of the judiciary. Public admission. And you think that we need another second definition of what constitutes stated misbehavior, and for which reason, without a regulation, we cannot operationalize Article 146.
Okay.
Come on, no, Sweetie, at least you gave him time, please.
I thought you were wrapping up. I mean, you are just responding to his...
Please.
Go ahead.
You gave him time. You see, so we must be careful not to go on that tangent. You can call for expanding the frontiers of Article 146. I am technically not against it. But as we stand now, as we sit, there's absolutely nothing wrong with that said provision. What you are simply trying to force on the Ghanaian people is your desires couched in a way to protect Madam Chief Justice suspended Torkonu. But you see, let us be honest for a bit. It is that it is difficult for us to define stated misbehavior. Why is my brother propounding this legal theories for? When you have a travel policy that regulates your conduct, when you have regulations that more or less prescribes what you need to do and what you need not to do, and you breach those policies.
Hold on. So does that not qualify as stated misbehavior?
If you breach
the provisions... I just want you to get responses to the questions you're posing.
I'm not posing the questions to you.
I mean, define some of the provisions or, the regulations for this travel policy and all that. Is that not misbehavior? If the Chief Justice is paying per diem for her spouse and child on a private trip,
let me ask
is that not misbehavior?
If very respectfully.
Briefly, and I have to return. It is time. Yeah.
If I take a gun and shoot him right now, right, it's killing. If driving on the road, it will result in his death. If driving on the road, I knock him down, right, it will also result in his death. Okay? But one is murder and one is manslaughter. It is not for anything that the law always gives side definitions. And so if you come and say that because somebody did this, it is
so it is not stated misbehavior. So that's what he's saying.
Ahead of time, you should know.
It's okay. It's okay. It's okay.
If the law had not,
to get clarity on what.
No. I don't need clarity from him because you see, it's clear that my brother is engaged in politics.
We have 2 minutes to move on to the next topic.
You see, again, it is important for us to appreciate that to assert that without a regulation, you cannot operationalize Article 146. It's an assertion that is strained to the law. Because I'm struggling to understand the constitutional or legal basis of such a claim. I have looked at Article 146. I do not see where it is stated. And I've looked at the entire Constitution. I am struggling to appreciate where it is stated that a regulation is needed to operationalize Article 146. If you are calling for us to expand the frontiers of the process, say so, but don't say that failure to have a regulation amounts to unconstitutional conduct, and for that matter, a way that would not make it possible to operationalize Article 146. We must make that distinction. But I heard him say that, no, without a regulation, you cannot operationalize Article 146. Where is it stated in our laws? Where is it stated in the Constitution? Absolutely nowhere. But if you are calling that having a regulation in place would make it easier, probable to interpret, to predict and understand, I would have no qualms whatsoever with you. Make it, because I am for anything that expands the frontiers of our constitutional organism.
He's asked where it is stated in the law.
Do you have it?
Yes.
Yes, you can provide. And secondly,
land on this point for me.
Okay, final. I'll try and land on that point. Finally, you see, sweetie, when you listen to the New Patriotic Party and its spokespersons, you get the sense that everything is wrong with our law only when they are those at the receiving end. But when they are those applying it against other people, there's everything beautiful about the spirit and letter of our Constitution. And that double standards, that hypocrisy must be seen through. If you want us to develop this country together, my brother, we must do so in a way that reflects the true aspirations of the Ghanaian people, not our petty partisanship.
Okay.
It cannot be that when you are in power, the laws, especially Article 146, is all good and rosy to move with. And so you can apply it to the likes of Charlotte Osei and Paul Derry and the likes. But when you are out of power, and the same yardstick, the same standard, the same laws you spoke for years is applied against you, then all of a sudden, there's everything wrong with the legal architecture of our country and must be condemned.
In accordance... According to Article 144, Clause 2 of the 1992 Constitution, which empowers the President to appoint justices to the highest courts of the land,
he has appointed.
Yes, I'll give you your time, and then you can use a bit of it to respond. We have a number of issues to touch on, so we have to speed this up. And the Speaker of Parliament has referred the President's appointment nominations to the Appointment Committee. I understand that minority has some concerns about that. You think these pack in the courts? What's going on there? Let's understand what you're saying. Feel free to use about a minute to reflect back on what
he said that I can say that we should pass a regulation to expand it so that there will be predictability. He used that word. That is the whole basis for Article 296 of the Constitution. That's it.